Hello, this is Justice Done Dirt Cheap. We're at the so-called Justice Building. How are you guys doing today? Would you like to introduce yourselves?
Sally Brooks. Jen Womble.
And would you like to do an interview?
Yes.
Wonderful. So you guys witnessed a oral decision today by Madam Justice Judy Clendenning. What are your thoughts on that?
I'm going to use my favorite word, shocked. I'm absolutely shocked again. She made a decision that's all about previous bad decisions that she's made. Obviously very biased in favour of the city of Fredericton's lawyer. And there was not 1 ounce of justice in sight.
Yes.
She basically ruled that Andre Murray has to pay security for costs on a matter that he's taken to appeal that is about the costs themselves being a wrongful decision by the judge. So how on earth can the judge be justified ordering a security for costs that are still in question as to whether they're even valid?
Yes.
Well, the judge herself said that there was numerous points that do have facts in it and that do warrant an appeal. That's what I got.
Yes, she basically didn't say that the appeal had no merit.
No, not one bit.
And she actually refused to comment more on that because it was about her own decision.
Yes.
So she didn't even pass a judgment on the merits of the appeal.
Which is what it was about.
Yes.
And as a caveat as well, the other decisions they're claiming to use as evidence that I haven't paid costs are other decisions that she actually rendered, which are part of live matters that are still not concluded.
Right.
I mean, one of the matters is regarding me getting paid $80,000 for work that I did on behalf of someone else. So because I'm seeking to be compensated for $80,000, they're saying that, well, so far there's been some cost awards against me, but the matter's not done.
Yep.
And whatever cost awards there are, which are nominal, it still doesn't, you still have to consider that I'm seeking $80,000 in redress. If they're pointing to the cost and saying, oh look, he hasn't paid the cost. Well yes, because the matter's not done.
Yes.
It's not over with yet.
Yes.
So maybe if they paid down payment on that $80,000, you could pay off your down payment.
Yes, we should make the reciprocal offer there perhaps.
But she also ordered that absolutely no more motions can be submitted or filed with respect to those issues by Andre Murray in the lower courts until the security is paid, which is basically saying your
no justice.
no justice, and your access to justice depends on money, which is not what the law is supposed to be about.
And what's interesting as well is that the city solicitor was not able to actually prove that I'm financially not capable of paying any judgments against me.
She didn't even ask, and the judge used it against you.
Yes. And what's
The judge
interesting,
didn't even ask.
the judge never asked, can you pay this?
Nope.
And I've asserted from the beginning that there's no evidence saying I can't pay it, and I'm not saying that I can't pay it. I never see. People must realize that when defending a motion like this, one can claim to be basically poor.
Yes.
They can say, well, I don't have the money, I should have access to anyways to justice, and that's not what I'm claiming. I'm not saying I'm broke and I can't pay it. I'm saying I want equal access to justice, and I don't believe I should have to pay beforehand.
Just
when,
to get it.
Yeah, just to get it, when simple process and procedure states that I have a right to go to the court, use the Court of Appeal to decide whether these costs should be awarded in the first place.
Yep.
I mean, this is just, it seems to be a procedural step the city's taking to try to make sure they're either going to hurt me on the way to appeal, as in cause me to pay, to play,
Yeah.
or they're trying to stop me from actually stop the matter from being heard on appeal.
They are trying to stop everything from being heard.
And I think they're also trying to make new issues.
I think they're trying to create a track record now that says Andre Murray's had 12 decisions rendered now. He's abusing court time. He's writing prolix, frivolous, vexatious documents. And every single decision and every single lawyer that is involved with this is compounding that. They're creating a trail of evidence that says, well, we've all agreed he's frivolous and vexatious and prolix and wasting everybody's time, while they are preventing it from being heard and from actual justice being rendered. They're creating their own case law to say this is not going to happen, Mr. Murray. We're creating case law that says we're going to shut you down. And I'm very interested that the case law that Madam Justice Clendenning quoted from was from 1976.
Yes.
So she obviously did a lot of trawling and searching
Just to find what you wanted.
to find what she wanted,
Yes.
which is what I'm also seeing the judges do. They trawl back and pick and choose what suits their purposes, and they discard the actual facts and the actual essence of the case.
What's interesting too is that case that is like the hot case regarding me, which is that Justice Robertson's decision, where he quoted all the different cases I was involved in and said that basically he wasn't going to grant leave to appeal. What people don't realize about that decision is that his decision was actually based, when you look at the Right to Information and Protection of Privacy Act, for some reason the lettering of the act makes it sound like one does not have the right to appeal a decision when it's brought before a Court of Queen's Bench judge regarding a review of a government body refusing to grant disclosure. So he said leave to appeal cannot be granted because he did not have the jurisdiction to do so, simply because of the wording of the act. And at the hearing, he even pointed out that even if the judge fell asleep through the whole hearing, if the judge was first cousins with the lawyer representing the other side, or no matter what type of conflict of interest, no matter how severe, it didn't matter, because he was claiming the Right to Information and Protection of Privacy Act barred leave to appeal. So what's interesting is to hide, it seems like there's an obfuscation of the fact that leave to appeal was just denied based on that technicality, and then there's this recounting of all these different matters I'm involved in illegally, which
Aren't relevant.
they're not relevant on that matter, but what it has done is paved the way for every other lawyer who wants to basically counteract whatever I'm doing to just hold this up as a little flag and say, oh look at this, you know, this big decision where he's not getting success. Well, not getting success doesn't mean that there wasn't merit there.
Absolutely.
There's many reasons.
Yes, it does. And what I'm seeing more and more is that provincial law is designed to trip people up and stop them having justice, and it's designed to make people forget about federal law being a higher law and constitutional law being higher. Provincial law always defers to the Charter
Yes.
and the Constitution, and you never see these judges actually enforcing Charter rights. You see them violating them every day, but not enforcing them or upholding them, which is their job.
Yes. And some of these decisions too that keep getting touted as reasons why I should, you know, I'm unsuccessful as an example. One of the ones I brought up earlier was regarding the mechanics lien, and according to the Mechanics Lien Act, I filed a motion for a continuance of the mechanics lien under the act. Now, I was the first hearing I went to, the judge totally did not allow me to be heard, and I was successful on appeal of that decision because it was so blatantly obvious that I was not given a fair hearing. The second time I had a hearing on the matter, I was before the same judge I was before today, Madam Justice Judy Clendenning, who decided not to grant the continuance of the mechanics lien action despite the circumstances I was under. And then the matter was not successful on appeal because it was stated that it was a discretionary decision. The Court of Appeal does not want to touch discretionary decisions most of the time. They just don't even bother overturning them. And then when the matter was brought to the Supreme Court of Canada, people don't realize that over 900 applications are made to the Supreme Court of Canada each year, and even though there may be 900 meritorious applications, only 80 are actually heard. So out of all the people who made application in that year, I was not one of the ones granted leave, and the Supreme Court doesn't even give reasons why they didn't grant leave.
And they tried to use that to make it look as though the Supreme Court decided you had no merit. Right. Whereas they just can't possibly hear all the cases. And
what's amazing is the merit was never actually heard because we never actually got to the point where the case went to trial. All we were at is a preliminary matter where all I was asking for was for an extension of time to like a continuance. It's considered continuance where after a year, if you haven't set the matter down for trial, just ask for a continuance and move on. And then that little minor technicality turned into about 2 years of going through various courts in New Brunswick, and the judges not having the the courage to speak out against lower court judges. It's just amazing.
I think New Brunswick is very protected by federal government and by the Judicial Council and by the Supreme Court of Canada. They, for some reason, are allowing New Brunswick to continue being run like it's the OK Corral.
Yes.
Making up the law as they go along.
Yes.
Nobody really enforcing anything. It's sickening.
So was there any surprise today hearing the decision?
No, I was surprised. I expected her to go for a token gesture of a down payment of a security, but she went the whole hog.
The whole 2/3.
Yeah, the only thing that was surprising is she didn't award more costs against you.
Yep.
Yes.
So she's obviously getting the message.
Yes.
She has to draw the line somewhere.
All right, and it's also noteworthy that Neil and Trina Rogers appeared again at this second hearing that had nothing to do with them personally. They were not actual moving parties to this motion.
I think they knew exactly what the outcome was going to be, and they came back to enjoy it.
Yep.
Yes. All right, well, thank you for that.
It's a pleasure.
Any final thoughts?
Just that IN needs to be written up there in front of justice.
Injustice, yes.
Yep.
Yep.
All right, thank you for that.
Pleasure.
Have a great day.
And you.
September 10, 2012, Justice done dirt cheap, in front of the Justice Building, Fredericton, New Brunswick. Thank you.